So with that, Representative Mecklen, did you get a chance to look at the minutes?
I did, Mr. Chair, and I moved the minutes.
Representative Mecklen moves approval of the minutes for February 20th, 2024. All in favor of the minutes, please say aye.
Aye.
Opposed? The minutes have been approved. First bill we have on our agenda today is House File 3882. I thought I saw, there's Representative Olson, and Representative Berg moves House File 3882 to be re-referred to the General Register. Welcome to the committee, Chair Olson.
Thank you, Mr. Chair, and thank you, members of the Labor Committee, for hearing House File 3882 today. So as I'm sure most everyone here, because I think everyone who was on this committee last year, heard the Earn Sick and Safe Time legislation that's worked its way through this chamber for a number of years that finally crossed the finish line last session. And as of January 1st of this year, that was the law of the land, and workers started to be able to accrue Earn Sick and Safe Time in our state, which has been great. We've heard stories across Minnesota about workers being moved to tears when they were able to take that first day of paid time off. Recently heard from a line cook who took a screenshot or sent out a picture of the DLI poster notifying him of his benefits and talking about it was the first time in his working career as a line cook he had ever had access to paid time off. So it's, what we had hoped for to make sure workers had access to the benefit is underway. And I would just like to say that the Department of Labor and Industry has done a phenomenal job going across the state and meeting with employers, employees, really helping to make sure that the rollout of this legislation went as smoothly as possible. And of course, in that process, the Department of Labor and Industry has heard ways that we can improve it, that we can clarify, that we can make fixes, that we can continue to work with stakeholders to make sure that it's as clear as possible so that it can be implemented so that workers can have these benefits. And so House File 3882 is really that. It's what the Department of Labor and Industry has heard and is putting forward as a set of potential technical changes and some corrections and clarifications that can make this law even better. And so with that, Mr. Chair, I'd like to turn it over to Commissioner Blissenbach.
Welcome to the meeting. Please state your name for the record and proceed with your testimony.
Thank you, Chair. Members of the committee, my name is Nicole Blissenbach. I'm the Commissioner of the Minnesota Department of Labor and Industry. Thank you for the opportunity to testify in support of House File 3882, the Earn Sick and Safe Time Cleanup Bill. The provisions in this bill were formed as the department implemented the Earn Sick and Safe Time law. DLI conducted extensive outreach and education for employers and heard from them about some of the challenges they were experiencing while implementing the law. DLI also heard from employer organizations about how the ESST law could better meet the needs of working people in the state of Minnesota, and their feedback was also instrumental in crafting the provisions of this bill. So I will do a walkthrough of what the bill is. So Section 1 adds statute section 177.50 to the Commissioner's Compliance Order Authority under 177.27. Section 2 provides the Commissioner rulemaking authority for Earn Sick and Safe Time. I should point out that the funding for rulemaking was included as part of the broader appropriation last session. So no additional appropriation is needed for this rulemaking addition. Section 3 lays out remedies related to an employer's failure to provide Earn Sick and Safe Time. Under this provision, the employer would be liable to the employee for an amount equal to all Earn Sick and Safe Time that should have been provided or could have been used at the employee's regular rate of pay, plus an additional amount as liquidated damages. This provision was added after speaking with some of the cities that have been doing Earn Sick and Safe Time ordinance enforcement, and the cities describing some of the challenges that they had in determining when ESST wasn't provided, trying to determine when, if ever, the worker would have used it, and trying to kind of recreate history as to when somebody would have needed access to that leave. So it's really clarifying what the remedy is for an individual who maybe was not provided Earn Sick and Safe Time at all, or who had been intimidated into not using earn sick and save time if we find that violation. Section 4 removes the current requirements employers must follow for providing information on earning statements. Section 11 will establish new requirements. This is directly related to feedback we received from employers saying that it was more challenging than what was expected to have the earn sick and save time directly on the earning statements. Section 5, which begins on line 5.4, makes a change related to how employers must calculate the rate at which earn sick and save time is paid. It changes hourly rate with regular rate of pay. We heard from some employers that the law wasn't clear as to whether bonuses or holiday pay or overtime pay would be required, and this was an attempt to clear that up. We also heard from employers who may be paying on salary or commission basis that using hourly rate of pay wasn't clear. We have received some additional communication on this, and just wanted to flag that we will continue to work on this to make sure that we're doing what is intended by this change, which is that regular rate of pay, that base rate of pay, is what is provided when somebody takes earn sick and save time. That would exclude bonuses, it would exclude overtime, it would exclude something like holiday pay. So trying to get that clarified, and that was something that was raised by employers during our outreach. Section 6 amends the definition of employee under earn sick and save time law by clarifying that an employee who is anticipated by the employer to work for at least 80 hours in a year qualifies as an employee. Some employers, as we were doing outreach, expressed confusion about whether employees were entitled to begin earn sick and save time on day one. And this is clarifying that, yes, that does start in effect with hour number 1. You begin earning the earn sick and save time. This is attempting to make that clearer in law. Section 7 amends the provisions in the law for accrual of earn sick and save time in cases where the employer chooses to front load earn sick and save time hours under the option of front-loading 48 hours. Employers are required to pay out the accrued but unused sick time at the end of the year. So this change updates the rate at which the employer must pay to match that regular rate of pay. Again, we will make sure that that is going to read as how we are intending, based on the earlier change I talked about. Section 8 amends the list of eligible uses for which an employee may use accrued earn sick and save time to include the need to make arrangements for funeral services or other matters related to the death of a family member. Section 9, the change on line 8.5, clarifies that an employer may require reasonable documentation that earn sick and save time is covered under the eligible uses in 181.9447 only when an employee uses earn sick and save time for more than 3 consecutive scheduled workdays. This change is meant to make it clearer that to employers that documentation can be requested only when it's used for more than 3 consecutive workdays. There were questions about calendar days versus workdays. I should add that. The change beginning on line 8.19 ensures that employees using earn sick and save time absences due to domestic abuse, sexual assault, or stalking of an employee or an employee's family member are not subject to more stringent documentation requirements than employees that are using that for other purposes. Section 10 addresses the increment of time in which earned sick and save time may be used. Previously, employees were entitled to use earned sick and save time in the smallest increment of time tracked by the employer's payroll system. This change provides that an employer is not required to provide leave in less than 15-minute increments. This was also something we heard from employers as being a challenge and not clearly stated. So this makes it more clear. Section 11, as I mentioned before, Section 4 removed the existing requirements employers must follow for providing information on the earning statements. So instead of requiring information on hours available for use and ESST hours on the earnings statements. The new requirements provide employers flexibility to provide this either on the earnings statement or electronically in a way that is accessible to the employee. It also requires that employees maintain these records for 3 years and that the records be available upon demand. It's common for payroll records to be maintained for a period of 3 years and those be available on demand. So section 12, paragraph B details the employer's obligation to destroy or return records under the Earned Sick and Safe Time law when requested by an employee. This provides that employers are not obligated to destroy or return if state or federal law, rule, or regulation requires the employer to retain those records. This was a change that was also requested by an employer. Section 13 provides that earned sick and safe time protections apply to all earned sick and safe time, not just the minimum amount of earned sick and safe time offered in the law. Lines 11.26 to 11.34 allow family workers in home care budget programs to waive earned sick and safe time. Just to clarify, this is a program where an individual is employed by a family member to provide those care services. The earned sick and safe time here, because it is a family member, would come directly out of that budget, and it allows that employee to waive that in only those circumstances. So it's a very narrow circumstance because it comes out of their family members, usually a parent or a child's budget. Section 14, this section of the Earned Sick and Safe Time law provides that when there is a separation from employment and an employee is rehired after the 180 days, previously accrued earned sick and safe time that has not been used must be reinstated. This change clarifies that only earned sick and safe time that has not been used or otherwise provided to the benefit of the employee upon separation must be reinstated. There were questions about, well, if we paid this into an HRA or an HSA, is that paid out? And so we've taken that position that it is, but this is making it clear that they don't have to reinstate that earned sick and safe time if it was paid out to the benefit of the employee. So I think that gets to the end of the bill. Thank you for the opportunity to testify in support of the bill. And of course, I will remain if there are any questions for me.
Thank you, Commissioner. Next, we're going to do the A1 amendment because that's an amendment that the author has said, and Representative Berg moves the A1 amendment. And if you want to explain what your amendment does.
Thank you, Mr. Chair. Essentially, the amendment puts flight crew, both pilots and flight attendants, back into the bill to be able to benefit from this law. So thank you, Mr. Chair. A special thank you to all of the pilots and flight attendants that are here today. It's so great to see what collective power makes possible, so welcome. Members of the committee, presumably you have all been on a plane or know people that have. And for a moment, I'd like you to picture that now. You may view your flight attendants as the annoying ones who interrupt your movie with our safety demos or make you get off your phone, even stand next to you, requiring you to fasten your seatbelt and stow your carry-on luggage appropriately. Later, however, you appreciate us because we bring you beverages and snacks. But here's the thing. Flight attendants and pilots must be able to react in an instant to face a variety of potential difficulties. Heart attacks, grave injuries, seizures, violent passengers, attempted flight deck breaches, imminent emergency landings. Pilots must be able to react to multiple possible dangers and keep the plane in the air or land it safely. We have the responsibility to ensure the safety of every soul on the plane at any given stage of flight. We want you and ourselves to arrive in the same condition as when we departed. We all want to go home to our families. Imagine that reaction time being delayed because we're sick. Seconds matter. We have extensive training to be able to prevent or lessen the impact of an emergency. But even that training has the potential to mean very little if any one of us is impaired due to illness. I have debilitating migraines, and I know that I'm not safe to fly in that condition. We can bring you a snack and potentially save your life at 35,000 feet. But in order to effectively do that, we have to be able to take care of ourselves, whether that means we're sick or a family member needs critical care, or if we need time to rectify not being safe at home. I'm the single income earner in my household, mostly because I'm single, or unless my kids are broke or hungry, then they're there. And my income and the ability to keep my job is threatened because of the sick policies most, if not all, airlines employ. Now, the airlines want you to believe that federal law preempts us from being able to qualify for inclusion in a state earned sick and safe time law. That's simply not true. Not only is it a workers' issue, but it's a safety issue. Safety for you and your families, and safety for us and ours. An airline's guiding principle is safety first. This amendment will ensure the airlines uphold that principle. It is time, and it is possible for us to benefit from this legislation like every other worker in the state of Minnesota. Thank you, Representative Olson, for bringing this law to fruition and accepting my amendment. And Mr. Chair, I believe I have a testifier.
Who's the testifier? Captain David Forbes. Welcome to the committee. State your name for the record. And
My name
proceed.
is David Forbes. Good afternoon. I'm a Delta Airlines local executive council chairman for Council 1 in Minneapolis. We represent the Airline Pilots Association. I'm also an Airbus A330 captain for Delta Airlines, based here in Minneapolis for the last 35 years. Council 1 has a storied history. We've represented airline pilots in the Twin Cities and in Minnesota since 1932. We are Council 1 of the many hundreds of councils now in the Airline Pilots Association. We were the first one. Very storied history. I'd like to take this opportunity to thank you, Mr. Chairman, and for letting me speak today. In addition, I'd like to thank my fellow crew member, Representative Berg, Vice Chairman, for allowing me to speak and for offering this amendment. On behalf of the thousands of pilots in Minnesota, we support this amendment presented by Representative Berg. The purpose of the amendment is simple. It ensures that flight crew, like Representative Berg and myself, along with the thousands of airline flight crew based in Minnesota, are treated the same as everyone else on this committee and in Minnesota under the Minnesota Earned Sick and Safe Time Law. Not only is treating flight crew different under the ESST unfair, but it's completely unnecessary. Some of you may have heard from airline representatives regarding the need to treat airline cabin crew differently because we are union members organized under the Railway Labor Act or because of the Airline Deregulation Act of 1978. Neither of these claims are true, and I'd like to set the record straight. Airlines claim that airline deregulation, ADA, preempts states from legislating on employment-related issues, including leave time. The ADA's narrowly drawn preemption simply relates to customer-facing state regulation issues of pricing, routes, and services. It does not extend to state labor laws, paid family and sick leave, or any related workplace rights granted by the state or its subdivision. The ESST does not fall into any of these categories and is not preempted. This is accepted law, with the Supreme Court recently declining to hear arguments otherwise. Minnesota, like other states, has the right to provide paid sick leave, but the individual and public health reasons for including flight crew under the state sick law should be the driving force for this much-needed fix. Airline employees frequently face punishment for using sick time and sick leave when they are sick. By including pilots and flight attendants in the Earned Sick and Safe Time law, Minnesota, like other states that lead in leave policy, will enable these employees to take sick time when they are ill, without facing penalty from their employer, and ensure they're not spreading their illness to their passengers and other workers. The ability to care for our loved ones in their time of need is an integral part of the ESST and provides a benefit that is otherwise denied to us as flight crew members. I want to thank you for your time today, and thank you for helping all Minnesota families, including flight crew members, for use of their sick time for our loved ones in this time of need, and we support this amendment. Thank you very much for your time.
Thank you, sir. Representative Olson, what's your pleasure with the A1 amendment?
Thank you, Mr. Chair and members, and thank you, Representative Berg, and thank you to the testifiers. I see this as a very friendly amendment. Our goal, I've said for a long time, is to cover as many workers as possible with this law, and this amendment very much follows suit with that. So I would urge members to vote yes.
Member questions? Representative Myers.
Thank you, Chair. Thank you, Representative Berg, Representative Olson. Representative Berg and the testifier, briefly touched on it a little bit, and so I'll pose the question to either of you two. Is there any consideration of potential lawsuit from this amendment?
Representative Berg, I guess.
Thank you, Mr. Chair, and thank you, Representative Myers. That is a great question, and the answer is yes.
Representative Myers.
That's all I needed. Thanks.
Any further? Representative McDonald.
Thank you, Mr. Chair. Representative Berg, curious as to what is the validity behind a yes answer? How could there be litigation? Is it based upon past state statutes of this kind that were proved into court that would be unconstitutional? Or what's the details?
Representative Berg.
Thank you, Mr. Chair, and thank you, Lead McDonald. No, there's nothing about it that's unconstitutional. It is something that has happened historically when states have implemented laws like our Earn Sick and Safe Time law. And so a lot of times it's just to sort of hash out the details, and decisions have been made where they have found a state's Earn Sick and Safe Time law to cover workers in that state, and some not.
Representative McDonald.
Thank you, Mr. Chair. Let's say there's a pilot for Delta lives in South Dakota, but he's based out of MSP and flies over several states. How is that calculated then, if that person is employed in Minnesota but lives in another state and probably just flying through or a flyover at a certain altitude, I'm sure? How are those hours accrued or calculated in sick and safe time?
And the commissioner might be able to answer that also, but Representative Berg, the commissioner, wants to come up and help if she can. Commissioner.
Chair Nelson and Representative, I may need the question repeated. I apologize.
Representative McDonald.
Thank you, Mr. Chair. Thank you, Commissioner. So if a pilot lives in another state but is based out of MSP, flying out of Minnesota and flying over various states and maybe a short time in Minnesota, how are those hours calculated and accrued? And if so, who keeps track of that? And what kind of law would govern that an employee who lives in another state who's just flying over or driving into and flying out of and flying into, how is that possible with the sick and safe time? How is that calculated, and how would that person be applicable to the law?
Commissioner.
Chair Nelson, Representative, what the Earn Sick and Safe Time law requires is that an employee earn at least 1 hour for every 30 hours worked in Minnesota. So the employer would have to track those hours, and that's how it would be allocated. And that's not an issue that is specific to airline. There are employees that work across state lines in many different industries, and that is something that state law applies within the state of Minnesota. It does not apply once you leave the state of Minnesota.
Representative McDonald.
Mr. Chair, thank you, Commissioner. So at what altitude does that no longer comply that that person would be in Minnesota? Is it 1,500 feet, 2,000 feet?
Commissioner.
Chair Nelson and Representative, I don't know the answer to that.
Commissioner, would it be any different if somebody, say a carpenter, lived in Wisconsin, worked here, and worked on jobs here and worked on jobs in Wisconsin, if they lived in Wisconsin, or they worked on jobs in Iowa, but they lived in Wisconsin, but when they also do work on jobs here, would it be different, applied differently than what we're applying this law?
Chair Nelson, it would apply the same way. I mean, the law addresses hours worked in Minnesota, and so the employer is supposed to be tracking hours worked in Minnesota. The same would be the case for ensuring that Minnesota minimum wage is earned for all hours worked in the state of Minnesota. We have a different minimum wage than our neighboring states do as well.
Representative McDonald.
Mr. Chair, yeah, I won't belabor the issue, but it is, hearing from constituents and business folks in my district, including my business as well, but this particular issue is perplexing to me because if, of course, a train driver, a truck, or an engineer, or a trucker is driving through Minnesota working, or a carpenter, but a pilot necessarily is only stationary. I suppose they get to the airport, they're probably lucky enough to get there an hour or 2 hours before. Some of us have to get there sooner. And then at one point they're flying up. I mean, I'm just curious, how are those hours accrued? Is it after he or she reaches a certain altitude? Is it the time spent on the ground? Just some of those questions.
Commissioner.
Chair Nelson, Representative, I think employers have to incorporate ways to track time. And I think that would be required here as well. I think there are also opportunities for employers. Earn sick and save time is a good policy to have as an employer. So it doesn't have to be complicated. You could accrue 1 hour for every 30 hours worked, regardless of where you're working. That is something an employer could choose to do. But if they are choosing to do something more narrow, they would just need to ensure that they're complying with the state of Minnesota laws within the state of Minnesota.
Representative McDonald.
Mr. Chair, thank you. Then I won't, I'll anticipate that answer and listen. But I do have a question regarding part of the bill, Mr. Chair. Is this a good time to ask that question? Well, actually, it's in the bill, so I'll wait till you adopt the amendment and then ask.
Mr. Chair.
Representative Schultz.
Thank you, Mr. Chair. Following up on Representative McDonald, I think we really need to look at the lens of this amendment and have for you, Commissioner, define for us what it means to be in Minnesota as it relates to this amendment and the way that this law would be executed and implemented. It's important for us to hear from you exactly what that definition is.
Commissioner.
Chair Nelson and Representative, I think that is great, a great reason to look at the bill that we have, which gives the department rulemaking authority, which is exactly what we would use it for, to help define some of the areas of the law that maybe not be in black and white.
Representative Schultz.
Thank you, Mr. Chair. I do think that this is something that we should be defining around this table rather than in rulemaking. And frankly, it probably should have been a part of this amendment in the drafting of it. We need to know those definitions. We're defining it for almost every other employee and employer in Minnesota, whether they're a local unit of government or whether they're an airline or whether they're a school. This is something that we've been defining in definitions, and I think it should be defined around this table rather than in rulemaking.
Any further questions?
I just have a quick.
Representative Mecklen.
Thank you, Mr. Chair. Maybe this would be a question for the pilot that testified. I'm not sure, or maybe Representative Berg, but if you fly from like Oregon to New York, for the time that you're over Minnesota, would that then count?
Yes.
So,
Please come to the, please do testify from the,
Can I
Yeah.
testify through the chair? Thank you. I'm
welcome
sorry.
back, welcome back, Captain Forbes.
My Robert's Rules of Order are weak at best.
Yeah, well,
so.
and we sometimes have,
And the whole anticipation of this is basically our time earned is we're based here. We're based in Minneapolis. We are Minneapolis-based pilots and flight attendants. Yes, we leave when we go to work, much like a trucker would do who works for Halver or Bay and Bay. The same thing if they're leaving the state lines, but we are Minneapolis-based pilots and flight attendants. Our work originates and ends here, and we are considered employees within the state of Minnesota, if that clarifies.
so, Captain Forbes, the way I heard the question asked, I could be wrong, but if you're a pilot flying from, and you're not based here, but flying from Oregon to New York, and you happen to fly over Minnesota, would you be subject to the laws of Minnesota?
And that's not a question for, I can answer. Our whole focus on this has been pilots and flight attendants who are based here in the state of Minnesota for Delta, Sun Country, and Endeavor.
Mr. Chair?
Representative Mecklen.
Thank you, Mr. Chair. The reason I ask you is because you're a pilot. I don't know. But so if each state along the path had different laws, would the airline then have to track each of them individually for the number of minutes in which you were over each individual state?
No, sir. The airlines calculate our work time based on our trip lengths and duty days and things like that, but it's all based as a Minnesota-based pilot. If the pilot's based in Chicago for United, for example, or New York for Delta Airlines, they fall under, at least throughout our company, under the laws of the state in which they're based in.
Representative Mecklen.
Thank you, Mr. Chair. Just one quick. So maybe it's not necessarily to Delta itself, but to others, maybe the commissioner can answer this, that how would it affect those pilots? I mean, is it dependent upon where they're based out of, whether or not Minnesota law is applied to them, or is it just for the time in which they're over Minnesota?
Thank you, Captain Forbes. Commissioner.
Thank you.
Mr. Chair, Representative, so the law says once you're an employee if you work 80 hours in Minnesota. So once you have met that threshold to be an employee under the law, then the requirements in the law would apply to the time that you're working here.
Okay, thank you.
Mr. Chair.
Representative Schultz.
Thank you, Mr. Chair. I would say that this is a really healthy discussion for us to have around this table, and I really appreciate the testimony that we've heard today, and for Representative Berg bringing this amendment today. I would say, just from the discussion and the concerns heard around the table, I'd really welcome for us to define this amendment better, and so I'm going to move to lay this amendment on the table.
Representative Schultz moves to lay the amendment on the table. It's non-debatable. All in favor of laying the bill on the table, please say aye. Aye. Opposed?
No.
The noes have it. Any further questions? If not, Representative Berg renews her motion to adopt the A1 amendment. All in favor of the A1 amendment, please say aye.
Aye.
Opposed? The A1 amendment is adopted. With that, we have a few more testifiers on the list here, and then we'll go to the rest of the amendments. I have Tim Bush, Maple Grove Fire Chief. And the Commissioner, if you want to pull one of the other chairs up. Okay. Welcome to the committee. Please state your name for the record and proceed with your testimony.
My name is Tim Bush. I've served 25 years as a paid-on-call firefighter with the City of Eagan from 1992 until 2017. I've served full-time with the Maple Grove Fire Department for 16 years, and I've been their fire chief since 2017. State agencies outside of the Office of the Auditor sometimes have a limited exposure to and understanding of paid-on-call firefighters. These firefighters are part-time employees of the fire department, but are different than almost every other type of part-time employee outside of public safety. The Maple Grove Fire Department, like many Minnesota departments, depends on paid-on-call firefighters to meet the emergency response needs of our community. Firefighters are given a radio pager and respond to their fire station when called to respond to fires and other emergencies. They're required to learn, earn, and maintain firefighter and emergency medical certifications. This is done through regular and often mandatory training drills. Most fire departments staffed with volunteer and paid-on-call firefighters establish call attendance standards that require responding to a minimum percentage of calls and training drills. In Maple Grove, our paid-on-call firefighters are required to respond to 30% of the paged calls for their assigned station and attend 80% of the regularly scheduled training drills. The current language of the Earned Sick and Safe Time law notes that employers are prohibited from counting earned sick and safe time in relation to attendance point systems. It further stipulates that employers are prevented from retaliation or other adverse action in regard to the use of ESST. The unique nature of paid-on-call firefighters is not addressed. I share the concern of many of my peers that this could require fire departments to provide ESST accommodation and pay while allowing individual paid-on-call firefighter participation to drop below established standards. The success of our staffing model is dependent on firefighters responding in a timely and appropriate manner when alerted by their pager. Firefighter recurrent training is critical in preserving and enhancing firefighter emergency response skills. It's important to make sure each firefighter attends required training to maintain standards established by the Minnesota Board of Fire Training and Education, the Minnesota Fire Service Certification Board, and the Minnesota Emergency Medical Services Regulatory Board, as well as OSHA requirements. In January, we received guidance specifically addressing how ESST applies to paid-on-call fire and ambulance personnel responding to a pager. The statute as currently written does not specifically address how ESST applies to special staffing consideration of paid-on-call firefighters not working scheduled shifts. The guidance provides an interpretation that the city is not required to permit ESST use by firefighters or ambulance personnel who miss an unassigned shift. Current guidance states that with assigned shifts, scheduled trainings, required meetings, and other events that are required, fire departments required to allow the use of ESST. If a paid-on-call firefighter does not have enough ESST accrued to cover the entire missed event, are they still excused from participation requirements for the entire missed activity? Firefighters are often required to complete mandatory training, including training that requires group participation. If using ESST will take a firefighter below minimum training standards, does ESST still excuse a firefighter from those requirements? I appreciate the guidance provided by Commissioner Blissenbach, and while maintaining a concern that guidance can be fluid and often in interpretation versus clearly spelled out language within a statute. The participation metrics used by fire departments helps to ensure that all firefighters receive critical training and maintain important skills they need when responding to fires and other emergencies. Those metrics also come into play with their firefighter pension. In the state of Minnesota, paid-on-call firefighters receive pensions either managed by a relief association or the State Board of Investments. And so to have those standards, if we aren't allowed to enforce those standards, it does create issues, especially in terms of fairness when it comes to the pension issues, as noted in the document from the League of Minnesota Cities and the Minnesota State Fire Chiefs Association.
Thank you, sir. Thank you for your testimony.
Thank you.
The next person I have on my list is Cap O'Rourke. Welcome to the committee. Please state your name for the record. Oops, don't hurt yourself, and proceed.
Mr. Chair, members, my name is Cap O'Rourke. I'm the Executive Director of Minnesota Association of Small Cities. I am up here testifying on behalf of the over 700 cities with populations under 5,000, and we have also been working alongside the League of Minnesota Cities. This fall, as the chief just testified, there is not a significant clarity about how this law will be applied to paid-on-call firefighters and volunteer firefighters. Our cities have been working hard to make sure that they are in compliance with the ESST law. And this fall, we had a Zoom call with the Department of Labor and Industry to work out some details about how this new law would be applied. One of the top questions was how it was going to be applied to our volunteer firefighters and our paid-on-call firefighters. And the response at that time is that it was still unclear and that they would get back to us with more clarity. The response we got after the new year with more clarity from FAQs did not clarify anything. In fact, two of the response that we received simply advised that our cities should go out and hire an employment law attorney. To have 700 plus cities and hire an employment law attorney to clarify how this law applies is simply not a realistic option for our small cities. We, as the chief mentioned, the required training that would be eligible under ESST to accrue hours if firefighters were to miss that, how does that apply to their firefighter credentials? And would it be considered an adverse action if we don't let them go out on calls because they've used accrued ESST time to not meet their training hours? We are simply asking for greater clarity from the Department of Labor and Industry exactly who should be covered and how that should be applied for our on-call and paid on-call firefighters.
Thank you, sir, for your testimony.
Thank you.
The next person I have is Lauren Schotthorst. Welcome to the committee. Please state your name for the record and proceed.
Thank you, Mr. Chair, members of the committee. My name is Lauren Schotthorst. I am the Director of Workplace Management and Workforce Development Policy for the Minnesota Chamber of Commerce, a statewide organization representing more than 6,300 businesses and more than 500,000 employees throughout Minnesota. On behalf of our members, a majority of whom are small to mid-sized businesses, thank you for the opportunity to comment on this legislation seeking to modify the recently enacted unfunded paid sick and safe time mandate imposed on Minnesota employers last session. During the 2023 legislative session, the Minnesota Chamber testified on numerous occasions with our staunch opposition to the imposition of this mandate for a number of reasons. We also sought to limit the scope of the mandate, provide our smallest businesses with some relief from the financial and operational impacts, and ensure employers have the flexibility to manage these new requirements in ways that are feasible and not cost prohibitive. Further, we specifically asked that legislators work to mitigate the burdens of the onerous compliance requirements that now necessitate the need for House File 3882. While this bill includes some clarifications necessary to reduce confusion resulting from the interpretation of this new law uncovered during its rollout and implementation, the Chamber more broadly supports the approach put forward in the DE1 amendment. The cost of doing business in the state increased significantly as a result of last session. After a record-setting number of new labor mandates, workplace restrictions, and business taxes, employers are very concerned about their ability to succeed and grow in Minnesota. The Chamber supports an approach that limits additional cost burdens and mandates on employers who are doing their best to keep Minnesotans employed. We also support enacting technical and substantive changes to address unnecessarily onerous compliance concerns, as well as statutory modifications to address overreach and issues uncovered during implementation. In that context, while we appreciate some of the clarifications that are included in the underlying bill, we believe that balanced employment-related policy benefits both employers and workers, as well as taxpayers, while enabling our economy to grow. It is for these reasons that the Chamber encourages members to pursue these clarifications while supporting the DE1 amendment. Thank you, Mr. Chair.
Thank you for your testimony. And something I sometimes forget to do, is there anybody else in the audience that wishes to speak for or against this bill? Come on down.
I'm being pretty careful today.
Again, welcome to the committee. Please state your name for the record.
Thank you. I'm Mark Hughes. Thanks for this opportunity, Chair Nelson and members of the committee. I'll make it as brief as I can. It bothers me because I think we have a labor versus management situation here that has nothing to do with this hearing room. But what I don't want to see is that somebody agree to disagree, which we have that right. What I don't want to see is Delta getting mad and pulling out of here, and all of a sudden we got to fly to Sioux Falls because they might be based in Sioux Falls, and that might be a way to get to our destination. I want everything kept here because they build houses with our construction companies, they buy our cars, buy our dishes, and help our economics just like everybody else. And this shouldn't be an issue that we can't fix. So what I'm saying, as the state of Minnesota, we want economic growth, not deficit. So let's fix this and move on. Thank you.
Thank you for your testimony. Again, is there anybody else? Seeing no hands, we'll go to the rest of the amendments. The first amendment I have is the DE1 amendment, and Representative Schultz. It looks like you're the one that's offering it.
Yes, thank you. I will move the DE1 amendment, Mr. Chair.
The DE1 amendment's been moved. You want to explain what the amendment does?
Absolutely. Thank you, Mr. Chair. And I'm just going to first start by welcoming Representative Olson and Chair Olson back to the committee. And just in case she doesn't make her way back to this committee, we've appreciated having you here and your expertise and knowledge over this bill and many others that have come before this committee, and appreciate your service to the state. Looking at this bill, I hope that as we approach this committee table in this bill, that we approach it from a perspective of trying to fix, trying to find positive changes that will positively impact both job creators, employers, and ultimately creating a strong dignity of work here in Minnesota amongst Minnesota's employees. And when in bringing forward the DE1 amendment, there are numerous examples of ways where we want to more clearly define the expectations for our business community, our small businesses, and ultimately for employers across the board, which is why I'm bringing this forward. There's a couple key things that this bill does or this amendment does, and I just want to highlight a few. There's a few instances, whether with a small business or small employer, where we really need the flexibility to operate. Think about a new business that has just formed, whether they only have a couple employees or they're just starting out, providing the flexibility for them to kind of have an on-ramp into ESST. And that's one of the provisions of the DE1 amendment. Additionally, one of the concerns that I have heard, and I hope that the commissioner and others who've been involved in implementation of this bill has heard, is that, and when Representative Olson is bringing forward this bill, there's a lot about notice requirements for employees to give to, or excuse me, employers to give to employees. And in the same token, the current bill that's before us today doesn't provide enough notice from employees to employers. I don't think that we want to grow a divide between businesses and employees more than already exists, and we want people to work together. And that's why this amendment brings forward the ideas and principles behind employees working more closely with their employers for notice as to when they are going to miss work. Because there are critical services and goods that are relying upon people showing up to work and providing employers enough opportunity to backfill those spaces so that we don't run into a situation where our supply chain struggles, where costs increase, where businesses aren't able to deliver the services or the goods for their customers, for the people of Minnesota. And so I'm bringing forward this amendment to bring about some humility, to bring about more of the concerns as we seek to bring about all of the voices at the table in Minnesota. And so I'm asking for support for this amendment and looking forward to hearing if we can work together on solving some of these challenges before this bill is passed this session.
Chair Olson.
Thank you, Mr. Chair, and thank you, Representative Schultz. And I think what we have in front of us is a bill that a lot of the technical and clarifications have come because of what has been heard in the rollout primarily from employers. So I look forward to your support of the underlying bill, whether it's amended or not with this. But I will ask for a no vote on the DE1. A couple of pieces you omitted to talk about with the DE1 were critical, and I feel like it's a relitigation of the bill that passed last year and a lot of the concerns you've had since the beginning. It eliminates part-time workers. Part-time workers tend to be low-income workers, BIPOC, women. That's core to who we want to make sure we're covering in this legislation. It would remove that. You're talking about changing the accrual rate. Right now, at the current bill, you have to work full-time for 6 weeks to earn 8 hours, and you want to bump up that accrual rate to make it take longer. There's several things in here, part-time workers, as I mentioned, several things that would fundamentally change who needs to be feeling the benefits of this law, changes to the definition of family, which I think we talked about extensively last year, why we went with the definitions we did. So a few of the things that you're not highlighting are you're trying to change in your underlying or the amendment, the DE1, that I very, very oppose and ask members of the committee to vote no.
Representative Schultz.
Thank you, Mr. Chair. Representative Olson, there's countless different examples of specifics in this bill in this amendment that would seek to change, tweak, and help our Minnesota employers ensure that they are able to have the same rights and the same opportunity to provide for goods and services for Minnesotans. Are you willing to work with myself and others concerned about notification for employers prior to this bill's passage?
Representative Olson.
Representative Schultz, I'm happy, and I've been meeting with all stakeholders. I've continued to talk to some of the testimony we've heard today from the League of Minnesota City, the on-call firefighters, continuing to work to figure out what solutions we can come to and what clarification we can work with DLI to provide, and that doesn't change, and I will continue to work on that until this bill is enacted.
Representative Schultz.
Thank you, Mr. Chair. I hear an openness, and I hope that that remains, Representative Olson, prior to this bill's passage. I do understand that there are no more committee stops per the discussion and the motion earlier today on this bill. And so getting that commitment from you is really important. So specifically on notification, Representative Olson, are you willing to work with the business community to ensure that employers have the opportunity to receive from their employees notification in advance of when they will be missing work so that we can provide products, goods, and services in line with the demands of consumers in Minnesota?
Representative Olson.
Thank you, Mr. Chair, and thank you, Representative Schultz. I can't promise you the outcome you're talking about, but I can certainly continue to talk with you. And one thing I will note with the notification is, I don't know about you, but I could go about waking up for my day, decide to go to work or school. I could get in a car accident. I could be in an emergency room. I could need to take the day off. I could get a call while driving here that my daughter is really sick and I need to go immediately. So I don't know what kind of notification you're talking about, but I believe in the spirit of making sure that the employer and the employer does have notification, but within the realm of what's possible for an employee to also live their life and to be able to use these benefits in a way that helps them, their families, their loved ones in times of need.
Representative Greenman.
Thank you, Mr. Chair, and thank you, Chair Olson, for this bill. And I just, looking at this, this DE, you're talking a lot about notice, but what I see is cutting out and sort of creating an unfair playing field for employees who are often the most vulnerable. So when I look at the definition of employees and who you're trying to exclude, mine are under 18. We heard in this legislature and passed with a bipartisan vote about making sure that 16 to 17-year-olds who are working and supporting their families had unemployment insurance benefits. I don't know about, if you're under 18, why you don't, if you get sick, you shouldn't have the access, or you need time to care. Employees working less than 24 hours a week, seasonal workers, all of these workers, and in committee, we oftentimes hear are the folks who are the most vulnerable and in cases most in need of this benefit. So when I look at this amendment and see that if you work for a small employer, you only get half the benefit, to me, it just feels really unfair for those workers. So I appreciate this work and would like to request a roll call because I think this is an important statement about what we think and how we think that the benefits should apply to all workers.
What's been requested, we'll have a roll call. Representative Schultz.
Thank you, Mr. Chair. I think there's just a number of ways where we want to ensure that on the more broader scale that this system isn't being abused. And it doesn't matter whether you're talking about employers or employees. The way that the current statute is written and this bill, there are far too many different opportunities for mishaps to happen, for there to be issues with the abuse of the system, whether that's because of employees at the very beginning of their tenure in their new job, accruing it, and also working within a seasonal business. Representative Greenman, there are places and opportunities in here that are going to provide too many opportunities for abuse. And so that's why we're bringing forward this DE1 amendment. And really, this is about bringing humility and helping lower costs and deliver products, goods, and services to Minnesotans reliably. That's what this is about, and ensuring that. So I encourage support of the DE1 amendment.
Any further questions? Representative McDonald.
Mr. Chair, I support the DE1 amendment, and for the sole reason that this was just passed last year, and in October became, the notice was sent out to businesses, and then became law January 1. So businesses, small businesses particularly, but all businesses had a hard opportunity, tough opportunity to really dig into the law and implement this for each employee. So we did mention when this bill was on the House floor and the floor and the committee last year that the implementation, we believed, was not enough time. It just became law. It was passed last year, became law January 1. And now if an employer makes a mistake on any numbers within that accrued time, they could be fined up to $10,000. Now, for any employer or small family business that's under, let's say, 25 employees or less, or a few, that's a very stiff fine. Now, the Commissioner Blissenbach did say at the time that they usually practice great compassion and discretion and good common sense in issuing that fine, but nevertheless, it's in state law, and they have every opportunity to implement that fine to an employer, a business, I call a family business, that may make a mistake. The current bill in front of us also gives the department rule-making authority, circumventing this committee itself. So any time that they decide that a certain rule is not working in favor of the department or collecting fines or whatever, they can have that opportunity for rulemaking. I think that should give us lawmakers some concern that we give the department rulemaking. Hearing from many businesses throughout this last year, with knowing that paid family sick leave is approaching in 2026, and then the sick and safe time, it's very expensive for businesses already, the mandates and the expense. This legislature has a habit of carving out certain exemptions for folks and groups of people. We have done that for years. For example, the paid family sick leave carves out an exemption of 50 employees or less for a meat packing plant in St. Cloud. The reason I favor this particular amendment, it does do a carve out for any employees that has a 25, or is it 50 or 25? What is it? 20? Yeah, 25 or more. So for those reasons, I do support the amendment. I think it's fair that we at least give an opportunity for businesses, small mom and pop businesses, an exemption, much like the federal government paid family leave does, and that our current law, the paid family sick leave from last year, we passed into law.
Further questions? If not, the clerk will take the roll.
Chair Nelson.
No.
Chair Nelson votes no. Vice Chair Berg.
No.
Vice Chair Berg votes no. Representative McDonald.
Yes.
Representative McDonald votes aye. Representative Daniels.
Yes.
Representative Daniels votes aye. Representative Greenman.
No.
Representative Greenman votes no. Representative Hill.
No.
Representative Hill votes no. Representative Hussein.
No.
Representative Hussein votes no. Representative Jordan.
No.
Representative Jordan votes no. Representative Kozlowski.
Gaween, no.
Representative Kozlowski votes no. Representative Meckland.
Yes.
Representative Meckland votes no. Sorry, aye. Excuse me.
Good try.
Jedi mind trick.
I was on a roll. Representative Meyer.
Aye.
Representative Meyer votes aye. Representative Schultz.
Aye.
Representative Schultz votes aye. And Representative Wolgamott is excused. There are 5 ayes and 7 nays.
With 5 ayes and 7 nays, the DE1 amendment is not adopted. The next amendment I have here is the A2 amendment. And who's going to offer that? Representative McDonald.
Mr. Chair, thank you. Well, we're 1 for 1, so this is an opportunity. I think that most folks will appreciate this particular amendment, especially if you are a fan, and I'm sure you all are, of our volunteer fire departments and ambulance drivers and those who are in elected office as well. So this particular A2 amendment, what it does is on page 5, line 16, Basically, what it does, a public officer who is elected to a governing body or person who is appointed to fill a vacancy in elected office of a governing body, a person appointed to serve on a board of commissions or governmental subdivision or an instrumental thereof, or an ambulance service personnel classified as a paid call or volunteer, and a firefighter classified as paid on-call or volunteer. So it exempts those folks from the bill of the safe and sick time.
Representative Olson.
Thank you, Mr. Chair and Representative McDonald. I ask for a no vote on the A2. We already have, and the commissioner can also speak to this, but in terms of lines 1.4 and 1.6, and of who those folks are already not considered employees and are not covered by earned sick and safe time, and DLI has provided that guidance. As for the other portions, I'm certainly happy to keep talking with folks, but DLI has offered guidance already, as mentioned, around scheduled shifts and how that is covered by earned sick and safe time regarding some of these for the ambulance and firefighter paid on-call volunteer pieces as well, and we can continue to keep working on that as well. But in terms of actually putting this into exemptions under the employer definition, I ask for a no vote on the A2.
Discussion. Representative McDonald.
Yeah, Mr. Chairman, perhaps I could split the motion? The amendment from the 1.8?
I guess I'll, tell us where you want to.
Well, no offense to those who are elected to a governing body. Some of us are elected here now. Or some of us were also on governing bodies in our hometowns. But the crust of the amendment really is to help our cities that have volunteer fire departments and ambulance drivers and on call. So we can leave out any board of commissions and those elected officials. Fine, we'll deal with those later. But really, I'd like to really help our firefighters and ambulance service personnel in our smaller cities that are volunteer.
And so.
So I would strike everything from 1.1 to 1.7.
So let me check with our staff here. Ms. James? Oops. Well, whether that makes sense, splitting it at line 1.8?
Thank you, Mr. Chair and Representative McDonald. So from a technical point of view, you would still need line 1.2. You would still need line 1.3. And then you would move to line 1.8, which would become clause 2. And line 1.9 would be clause 3, I believe. And then on line 1.10, the 6 would become clause 5. And I'm happy to follow up with the revisor to make sure all these technical changes are adopted.
So just so everybody understands what we're doing, we're basically deleting or striking 1.4 to 1.7 and leaving the rest of the amendment. Is that what your intention is?
Mr. Chair, yeah, thank you for the help. I should have known that. I forgot to put on these cheaters, but you're correct. We certainly don't want to strike those first 3 lines. So that would be the suggestion.
So Representative Olson.
Mr. Chair, Representative McDonald, I still request a no vote on the A2 for the point that DLI has offered a lot of clarification. And again, if you notice the definition of employer, we don't have much spelled out there in terms of exemptions. And I am not in favor of putting that there, but I am in favor of figuring out if they need further clarification, how we could continue to offer that to them. So a no vote on the A2.
Mr. Chair.
Representative Schultz.
Thank you, Mr. Chair. And Representative Olson, are you suggesting that the best guidance on this particular discussion is for that to happen in rulemaking?
Representative Olson.
Representative Chair Nelson and Representative Schultz, no, that's not what I'm suggesting.
Representative Schultz.
Thank you, Mr. Chair. Representative Olson, what is the remedy that you're suggesting?
Representative Olson.
Chair Nelson, and I can ask the commissioner too. The commissioner is able to provide guidance, and we felt some of it had been met satisfactorily to be able to administer this law in these situations, but that clearly isn't the case from the testimony. And I have spoke to the League of Minnesota Cities, earlier today about my continued commitment to work to figure out if there is a way that they need further clarification in law that is not in the definition of employer.
Representative Schultz. Representative McDonald.
Yeah, I request a roll call on this new amendment of mine. And then a question for Representative Olson as well.
Hang on a second.
This divided. I don't know if do we have to? Without.
So Representative McDonald was whispered in my ear here, and just want to make sure that, are you intending on, if we vote on the second half, offering the first part, or do you just want to delete lines 1.4 to 1.7 from your amendment? To amend your amendment to delete that portion?
I believe that's correct.
So, okay, so what we'll do then first here is, so Representative McDonald is moving to amend his amendment to delete lines 1.4 to 1.7 and allow staff to make the corrections with numbers as needed. Does that work, Ms. James?
Mr. Chair, yes, that's correct.
So we'll take a vote on the amendment to the amendment. All in favor of the amendment to delete line 1.4 to 1.7 from the A2 amendment, please say aye.
Aye.
Opposed? The ayes have it, so we deleted the 1.4 to 1.7. And now you want a roll call on the rest of the amendment. Any further discussion before we go to the roll call? Seeing no hands jumping up, clerk will take the roll.
Chair Nelson.
No.
Chair Nelson votes no. Vice Chair Berg.
No.
Vice Chair Berg votes no. Representative McDonald.
Yes.
Representative McDonald votes aye. Representative Daniels.
Aye.
Representative Daniel votes aye. Representative Greenman.
No.
Representative Greenman votes no. Representative Hill.
No.
Representative Hill votes no. Representative Hussein. No. Representative Hussein votes no. Representative Jordan.
No.
Representative Jordan votes no. Representative Kozlowski.
No.
Representative Kozlowski votes no. Representative Mecklen.
Yes.
Representative Mecklen votes aye. Representative Myers.
Aye.
Representative Myers votes aye. Representative Schultz.
Aye.
Representative Schultz votes aye. There are 5 ayes and 7 nays.
With 5 ayes and 7 nays, the amended A2 amendment is not adopted.
Yeah.
It's nice to have staff to keep us straight, so we do the right thing. Anyway, next we have the A4 amendment.
Thank you, Mr. Chair.
Representative Schultz?
Yes, I move the A4 amendment.
Representative Schultz moves the A4 amendment. And do you want to explain what your amendment does?
Yes, thank you, Mr. Chair. Back home and throughout the state of Minnesota, many employers, specifically in the public realm, whether you're talking about counties, municipalities, and in this instance, schools, have had a challenge implementing the new Earn Sick and Safe Time mandate. And as a part of that, my concern for our committee and for the whole of the state is we are seeing less programming in our schools because of the heavy-handed, one-size-fits-all unfunded mandates of this bill. And so this amendment brings forward the chance for us to remove short call substitute teachers or temporary employees who are employed for fewer than 90 days of a school year from this legislation. And this is a positive step. There are countless examples of schools who have not been able to provide the programming for their students to achieve excellence from the youngest of learners. We're talking about the people who help first graders read. And having an inflexible, one-size-fits-all, unfunded mandate on our schools that has greatly impacted the future of our kids, which none of us want. These additional mandates are really hurting our schools. And this is one small way that we can help that problem and can ensure that the great people who go to help in our schools as substitute teachers and and temporary employees, that they're able to continue to do that where without a heavy-handed mandate that doesn't fit individual school districts best. So that's my goal with the A4 amendment, and I encourage your support.
Representative Schultz. Or Representative Olson, never. I'm looking now. Anyway.
Thank you, Mr. Chair. And Representative Schultz, I also request a no vote on the A4. Substitute teachers get sick, temporary employees get sick, and if you're working for that 90 days, that's 3 months, you'd accrue about 24 hours in the time, and that seems very fair and reasonable. And I think that because everyone gets sick, whether you're a temporary employee or a substitute teacher, or you have family emergencies, or you have a situation of domestic violence, everybody deserves these protections, and it leads to better outcomes for our students. As being married to an educator with a second grader, I want to make sure everybody has the time off they need and can come to school in the best shape they need to be educators to our kids. So with that, I request a no vote on the A4.
Representative Schultz.
Thank you, Mr. Chair. Representative Olson, I'm disappointed to hear that there's a lack of flexibility here. But what should we be surprised with? This is the attitude of the DFL majority. Shove through heavy-handed, unfunded mandates to our schools that take away programming for our kids. That's what this is about, programming for our kids. First, second, and third graders are not going to have the people that they need in their schools because of a policy like this that is unfunded into the future and that hampers our ability to provide services and programming to our kids. That's what this is about, and I encourage your support.
Any further discussion? If not, all in favor of the A4 amendment, please say aye. Aye. Opposed?
No.
The noes have it. The A4 amendment is not adopted. Members, just in our packets, there was also letters from numerous organizations, and those have been posted online. And so any further discussion on the bill? Any further discussion on the
Yes,
bill?
Mr. Chair.
Representative Schultz.
Thank you. Thank you, Mr. Chair. Thank you again, Representative Olson. I wish that you were open to more changes, more fixes, as this legislative session should be focused upon that. So disappointed to hear kind of the general attitude, despite how much I enjoy your good work that you do at the legislature. So I do have a few questions for you and more so for the commissioner. Commissioner, my first question for you is, there are very minor, and I believe I saw two specific points in this this new bill that really support the concerns of employers in this state. Is this bill truly encompassing of all of the concerns that you heard from businesses and employers throughout the state?
Commissioner.
Chair Nelson and Representative, so there are more than two provisions in this bill that were directly as the result of conversations that I or other DLI staff have had with employers, employer organizations around the state, specifically the rate of pay, the pay stub issue or the earning statement issue, the increments of time issue. There are more, and I know that there are at least those three. I think there are a few more. But we worked with stakeholders to issue guidance where possible to resolve concerns, which that happened on a number of occasions. We worked where it made sense with the policy we were trying to promote with Earn Sick and Save Time to bring the ones that weren't addressed, that could not be addressed through guidance and needed a legal change to incorporate those into this bill. There are, of course, concerns that were raised about coverage that did not align with the policy of Earn Sick and Save Time from its origination. It shouldn't matter where somebody works to have access to Earn Sick and Save Time, how much they work. Everybody gets sick, and everybody should have access to Earn Sick and Save Time.
Representative Schultz.
Thank you, Mr. Chair. So to the commissioner in particular, my understanding is there were two major pieces of guidance provided to employers across the state, one in late October and one in early December. You've been working on this for 5 years. This bill, this idea has been one that has permeated the Department of Labor and Industry. why didn't our employers get more access to information for implementation prior to late October and early December when they had to have this implemented by January 1st?
Commissioner.
Chair Nelson, Representative. So the bill passed last session. We can't, as a department, begin implementing something until it becomes law. When it became law, we immediately started developing resources, doing outreach. I think the week after session, maybe I'm a week off, I recorded a presentation with the Minnesota Chamber of Commerce that specifically talked about the Earn Sick and Save Time law. We had information up on our website on May 25th of 2023. We posted an ESST fact sheet on June 8th, an overview video on September 7th, an ESST employee notice, an example notice in November, an optional workplace poster on November 16th. We published FAQs on August 17th and additional FAQs in September, October, and December. So we've been working on this. We've also met, I think we've counted the number of participants in outreach and education events, and it has totaled over 9,000. So we've been working on this nonstop with our staff at the department to make sure that the information related to compliance with this law is out to both employees and employers around the state.
Representative Schultz.
Thank you, Mr. Chair. I'm not going to belabor the point because I know there's other questions around the table, but my concern is we went into full implementation of this in January 1st, and employers didn't hardly have the information available to them, despite the fact that this has been a priority of the department for so long. And so I'll yield the floor.
Any further questions? Representative McDonald.
Thank you, Mr. Chair. Question on the lines subdivision 5, under the definition of employee. It's being changed to, it reads, employee means any person who is employed by an employer, including temporary and part-time employee, who, we're striking the word performs and adding is anticipated by the employer to perform. So what, that seems a little vague, Commissioner, anticipated by the employer to perform. Who anticipates and what is to anticipate? How can you interpret that in the law?
Commissioner.
Chair Nelson and Representative, this clarification is to provide additional clarity for employers about when an employee starts to earn sick and safe time. So there was confusion about whether that started on that 80th hour or if that started on hour 1. And many employers, when they hire someone, they know that this is a hire that they hope will be many years, maybe till retirement. And so to clarify that earn sick and safe time begins accrual on day 1, hour 1. If it is a temp situation and you're not sure how long the employee would be in that position, then it wouldn't accrue until they hit that 80th hour.
Representative McDonald.
Thank you. And that answers my question on that.
Representative Mecklen.
Thank you, Mr. Chair. To the Commissioner, I want to say, I was trying to find the date in my calendar, but I think it was in mid-October. One of your staff members did a training session for Central Minnesota Builders Association, which I attended virtually because I was actually driving down to the Department of Labor. In that, there was a tremendous amount of really good questions asked, but quite often he's like, we don't know yet. And so, I mean, I was driving, so I wasn't taking notes, but there is so much uncertainty about a lot of these different things, and everybody's affected significantly different and with these steep penalties. But one question that I was asked, so if you acquire 80 hours through a course of 2 years, correct, of earned safe time, 48 a year, and then up to 80, right?
Mr. Chair, Representative, it would not necessarily, it depends on what method you're choosing. If it's accrual, then the limit is 48. If you are doing a front load option, then what you would front load is 80 hours if you don't want to have at the end of that year to pay out the additional hours.
Mr. Chair.
Representative Mecklen.
Thank you, Mr. Chair. Right, okay. So if in the third year you receive a significant promotion or there's been a contract negotiation, so now you're paid substantially more than you were when you earned this sick and safe time, which rate is it paid at?
Commissioner.
Mr. Chair, Representative, the rate that, your rate of pay, your hourly rate of pay, that's what the current law says. Under this, we're trying to clarify that it would be the rate of pay that wouldn't include additional things like holiday pay or, I'm assuming you're talking about a salaried employee, though. If it's a substantial amount of money they're earning, it would be at their rate of pay.
Mr. Chair.
Representative Mecklen.
Thank you, Mr. Chair. So if the statement of wage went up a buck an hour in year 3, after you've accrued 80 hours and you have it banked, when they choose to use that sick and safe time or they become ill, what is the rate that they're getting paid at when they're using it? When it was earned at, or what the year in which it is they're using it?
Commissioner, and I guess, to me, it sounds like it's no different than someone that can accrue sick leave. They may have got accrued those hours 2 years ago, and then Representative Mecklen's case, they got a big raise, or they got a raise. I guess what I'm looking at is they would be paid at the rate they're being paid at the current time, not the rate that they paid it, and I think that's what he's getting at.
And Chair Nelson, Representative, that is correct. It's at the time, your rate of pay at the time you were using the leave.
Mr. Chair.
Representative Mecklen.
Thank you, Mr. Chair. Is that delineated in the statute? Is that clear?
Commissioner.
Mr. Chair, Representative, it does say that it's at your rate of pay. I think the current language is hourly rate of pay. Under the amendment, it would be your regular rate of pay, but that would be at the time you're taking the leave. Yes.
Mr. Chair.
Mecklen.
Thank you, Mr. Chair. That's what I'm trying to get at. I cannot find where it says at the time it was used, or where it's very clear that everybody understands that it's not at what it was earned at. So in other words, if that bank, if you were to say that those first 48 hours, right, just for easy numbers, it was at $10 an hour, that's $480 worth of paid time off. And the second one was maybe at $11 an hour. But the third one, maybe they're at $12 an hour, which, I mean, is it a completely, I mean, this is the part of the problem when there's so many questions and nobody's really sure and nobody really wants one of your $10,000 fines. And especially if they have multiple employees in a bigger atmosphere where you could be perceived that one mistake was 50 mistakes. So I think what everybody's looking for is some very, very clear guidance on all this, because each and every one of our businesses are very different. And I mean, I've talked to the school quite a bit, and they're struggling with this. And obviously, there's a lot of employees. And just even the record keeping, like, can we just say, the heck with it, we're going to give them 90 hours of paid time off, and are we covered, or do we have to track every little thing, every hour in, every hour out? I mean, and do we have to be able to prove all this? And failure to do so to try to streamline things or not have to hire more people to do all this new documentation, which then goes to us taxpayers that fund the school. So this is where I think a lot of this is coming from. But if you have found where it clearly states that it is at the time specifically when the benefit is used.
Chair Nelson and Representative, so in the bill today, if you look at subdivision 4, it does say earned sick and safe time is paid at the employee's regular rate of pay. It doesn't say at the time that the sick leave was earned. It says at the employee's regular rate of pay and may be used for the same purposes under the law.
And members, it's 2:25. We can go a few minutes late beyond our committee time, but we need to vote on this before we go on. And we do have another bill, but that we can bump that one to another day. Representative Mecklen.
Mr. Chair, thank you. Again, that's my point. It does not clarify what the regular rate of pay was. It the rate of pay in which the benefit was earned, or when it was used? Because you're literally giving them pay for something they earned back then. You're giving them more, which I'm not saying that's a bad thing, but what if they didn't understand that? What if they accrued it at the old rate, not knowing, and certainly not meaning to do anything? But especially like if someone was promoted to, I don't know, think like a car dealership or something where they suddenly are making a lot more money selling cars, and so now they earned all this over 2 years, and maybe they became a sales manager or something, and now they make a significant amount more money. So now you're saying that those 80 hours are now going to be paid at double the amount possibly. But they're supposed to know all that. But I'll leave it there with her answer, Mr. Chair.
Commissioner?
Mr. Chair, Representative, I think the statute is clear that it's paid at the rate that you are making when you are taking the leave.
Representative Myers?
Thank you, Chair Nelson. Thank you, Representative Olson. I know we worked on a little bit of this last session, and I want to follow up on that. So the question I would have for you is that, is the intent to go ahead and update the notice requirements so that we try to minimize some of the potential penalties that we've seen, both for employers, employees, to update the notice requirements with the changes that are going to be in here?
Commissioner?
And Chair Nelson, Representative, the changes are to the requirements that would be on the earnings statement. And what it's changing is, instead of requiring the hours that are available for use be on the earnings statement, they could be on the earnings statement, or they could be in an electronic format that's available to the employee. This is in direct response to concerns we heard from employers about the inability to reflect the earned sick and safe time hours on that earnings statement.
Representative Myers?
Thank you. And the reason I say that is, there are some, new things in here talking about record keeping, 72 hours. The hope is that, we can balance that approach to both employees, owners, operators, knowing what the requirements are for them. And that was something that, Representative Olson and I had talked about, to make sure that we can do everything we can to make sure that, the fines are going to egregious, issues. The one thing I would ask, though, is if you look at that line 9.28 through 9.31, and I'd like to talk more about this, outside committee, but I just don't think that the 72 hours is a reasonable amount of time for small businesses, the impact that this has. One question I would have is, how did you come up with that time frame, and would you be willing to talk a little bit more about maybe giving additional time?
Commissioner?
Chair Nelson, Representative, that is language that exists in our wage and hour enforcement for payroll records. So it's not new language. It's language that, as we say, borrow from places that we already know, that we used from the demands that the department can already issue related to pay. This would just be to cover the things that, if there is a different system used, it would be to cover that system for the earned sick and safe time.
Representative Myers?
Thank you for that clarification. I do still think this is, again, another layer that is put on owners and operators, and I would hope that the author would be willing to consider some additional time, as this is a new thing for a lot of people, and it is impacting, really small businesses as well.
Any further questions? Representative McDonald.
Thank you, Mr. Chair. Just a real quick softball questions to the commissioner. Will anything, once this becomes, if it does, get voted on and passed and becomes law, is there more material need to be communicated to employers throughout the state, and what length of time will that take, if so?
Commissioner.
Chair Nelson and Representative, we would take what is in this, incorporate it into the guidance. It allows us to provide some clarity maybe where we couldn't before, or to provide additional guidance where we have provided some. So I believe we could do that. These are changes that we are anticipating, and that, to be honest, we are hoping to make, because it would make our ability to provide that guidance easier. So I expect that we could do it fairly quickly.
Representative McDonald.
Thank you, Mr. Chair. Thank you, Commissioner. And then as far as the funding from last year's bill, I think it was $1.4 million. Is there I would presume it didn't take all of that yet, and you're still implementing this as well, and communicating to employers. Is there still some funds left over in that original allocation of funds?
Commissioner.
Chair Nelson, Representative, so we have not touched the amount of money we were allocated for rulemaking, because we are unable to do that until we have that authority. The money has been used for outreach, education efforts. It has also been used to hire additional staff. So I do not have a dollar amount of how much money is remaining for the biennium, but I do know that the rulemaking money has not been touched.
Representative McDonald.
And then last question, and I like when politicians say it, last question, like Columbo. Excuse me, last question. No, this is the last question. Regarding rulemaking, Sometimes it's pertinent to give agencies rulemaking, sometimes it's a little conspicuous, but in any future rulemaking authority that you will be granted, there's no intention of changing the law or any penalties or anything like that for employers, is there?
Commissioner.
Chair Nelson, Representative, we can't do that through rulemaking. We can only fill in the gaps or areas that the law doesn't address. We cannot change it or provide ourselves with additional authority.
Any further questions? If not, Representative Berg renews her motion that House File 3882 as amended be referred to the General Register. All in favor of 3882, please say aye.
Aye.
Opposed?
Aye.
The ayes have it. The bill's on its way. Members, the other bill we've got, and it would help get it out of the way and off our calendar, is the very small bill. You think we can get that done in 5 minutes?
Sure. As long as Schultz doesn't talk.
We'll pass it out.
I second that amendment.
Yep. And we're passing this out. This is House File 3442.
Okay, let's do it though, because we gotta get out of here. Literally.
I'll let Representative Berg get in her seat.
Kayla.
So much for your 5 minutes.
Yeah.
I can't help it, people like.
Hey, prepare for takeoff.
Thank you guys all.
Kayla, we gotta go.
I know. Do you want me to?
Okay.
And if we can get back in order here,
Leash. Leash.
Leash,
Come on.
House File 3482. And this is going to be laid over
Yes.
for possible inclusion.
Yes.
So Representative Berg moves a House File 3442 be laid over for possible inclusion. Do you want to explain the bill?
Yes, thank you, Mr. Chair. Oh, wow, sorry about that.
It's okay.
So last year, after the law banning captive audience meetings went into effect, we heard from DLI that employers have asked for a template of the poster required under the law. This would make it consistent with the workplace veterans posters, for example, which contains information about rights and benefits that are not enforced or administered by DLI, but for which DLI was required and did create a poster for. And then just a recap on the captive audience law. It prohibits employers from retaliating against workers who decline to attend a meeting or receive communications if the purpose is to convey the employer's opinion on political or religious matters. It's a very simple bill. If there are any questions, I do have someone here to answer them, but otherwise, that's what the bill is.
And the commissioner's still here, so any questions on the bill? Representative Myers.
Thank you, Chair. Thank you, Representative Berg. Question I have, just, really short bill, but if the information is wrong, if the information is not up to date, is the commissioner being held liable for this?
I guess,
Well, I mean, the
Looks like the
state, sorry.
commissioner
Not the commissioner
Members,
personally, that's not what I
Members,
meant.
And members, in your packet, there is a fiscal note on this, which I'll let the commissioner answer the question. Commissioner, welcome back.
Mr. Chair, Representative, so when we develop posters, we basically follow the language of the law in developing that poster. So we would stick to developing that based on the specific language that is in the statute.
Representative Myers.
Thank you. So if the statute or things change over time, is it going to be the responsibility of the commissioner and the office to update those and provide those back out to owners and operators?
Commissioner.
Mr. Chair, Representative, yes, just like we do with the minimum wage poster, we update it each year to reflect the new minimum wage that takes effect on January 1 of each year.
Thank you.
Representative Myers. Any further questions? If not, all in favor of House File, Representative Berg renews her motion that House File 3442 be laid over, and we don't need to vote on it because we're going to lay this over.
Thank you, Mr. Chair.
Thank you, members and members. With that, thank you for being cooperative and getting through the meeting. With that, we're adjourned.